Hello and Namaste. I am Ketan Kank from 192 Consulting. This is part 3 video of Rule 7 of IPF rules. In part 1, we considered sub-rules 1 to 4, in part 2, 5 to 7, and in part 3, we are going to consider from sub-rule 8 to sub-rule 11. So let us see what sub-rule 8 has to say. Sub-rule 8 of Rule 7 of IPF rules states that in case the claimant is a legal heir or successor or administrator or nominee of the registered shareholder, the claimant shall ensure to submission of self-attested scanned copy of all documents detailed in Schedule 2 of these rules along with form number IPF 5, provided that in case of loss of securities held in physical form, he has to ensure the submission of self-attested scanned copy of additional documents detailed in Schedule 3 of these rules online along with Form 5, and provided further that the claimant shall submit in original all these documents duly signed by him to the nodal officer of the concerned company at its registered office for verification of the claim. Sub-rule 8 deals with transmission cases, and it states that the documents, if it is a particularly a transmission case, then the documents mentioned in Schedule 2 and Schedule 3 should be submitted along with IPF 5 and the regular documents that go with IPF 5. Now, what are the documents mentioned in Schedule 2 and Schedule 3? We will be taking care of them in separate videos, because there is list of documents and it has to be reflected or it has to be discussed meticulously and separately. So that's why we are keeping it for separate videos. In the upcoming videos, we will talk about them. But sub-rule 8 of Rule 7 deals with the transmission cases and the documents to be submitted related to the transmission of shares. Sub-rule 9, in case the claimant is legal heir or successor or administrator or nominee of any other registered security, or in cases where request of transfer or transmission of share is received after the transfer of shares by the company to the authority, the company shall verify all requisite documents required for registering transfer or transmission and shall issue letter to the claimant indicating his entitlement to the said security and furnish a copy of the same to the authority while verifying the claim of such claimant through the e-verification report, provided that the authority shall dispose such request of transfer or transmission based on the e-verification report of the company subject to the verification of such request. So, sub-rule 9 states that in case there is transfer or transmission of shares and it receives such a request of transfer or transmission, then it should carefully look into the documents and then provide its e-verification report to the Investor Education and Protection Fund Authority. Now, let us see what sub-rule 10 used to say. Now, I am specifically saying why sub-rule 10 used to say. I'll come to it later, but let me first read out what was the requirement mentioned in sub-rule 10. Sub-rule 10 stated that the claimant shall file only one consolidated claim in respect of a company in a financial year. So, earlier there was a restriction of filing one consolidated claim for one company in one financial year, but now sub-rule 10 has been omitted and the claimant can file other claims also or more than one claims also pertaining to one company in one financial year. Now, going ahead with sub-rule 11, what sub-rule 11 states is the company shall be liable under all circumstances whatsoever to indemnify the authority in case of any dispute or lawsuit that may be initiated due to any incongruity or inconsistency or disparity in the verification report or otherwise, and the authority shall not be liable to indemnify the security holder or the company for any liability arising out of any discrepancy in verification report submitted leading to any litigation or complaint filing thereof. Again, the authority is actually safeguarding its interests into this by making the company liable and also stating that the authority will not indemnify the company or the security holder in case any security holder. So, by this provision, the responsibility of the nodal officers of the company increase manifold. The nodal officer of the company has to be very clear about anything happens to the claim or any lawsuit arises out of the claim which is already been approved or for which an approved e-verification report has been filed by the nodal officer. and investors have to be very clear about mentioning the details of the securities and other details on the forms or the documents which are filed with the company. So the authority will not indemnify in case any lawsuit arises or in case there is any fraudulent malpractice about the claim. The onus completely lies on the company and the investors. Investors have to be extra vigilant while filing the claim. Clause B of Subrule 11 states, any fraudulent claim by the claimant shall be deemed to be fraud within the meaning of section 447 of the Act, and the claimant shall be liable accordingly. So again, the fraudulent liability comes on the claimant. The onus entirely lies on the claimant. It is advised that a professional guidance should be taken by the investors while mentioning the details, because even a single misinformation can cause huge problems for the investors or the claimants. Subclause C of Subrule 11 states, if any person deceitfully personates any owner of any security or of any share warrant or coupon issued in pursuance of this Act and thereby files any claim to obtain or attempts to obtain any such security or interest or any such warrant or coupon due to the lawful owner, he shall be punishable under section 57, section 447 and 448 of the Act, which deals with the criminal offenses. So this is a criminal offense. Investors are advised not to indulge into any kind of malpractice which will actually attract problems for them. This was Rule 7 in Part 1, Part 2 and Part 3. With the completion of Part 3, we have concluded Rule 7 and aspects relating to the refund of securities. Should you have any query relating to the refund of securities, reclaiming of the shares and investments, dematerialization of shares or any other investment related queries, you may please feel free to reach out to us. You can reach out to us by marking your comment in the comment section of this video, or you can also write an email to us on info@nineteenTwo.in. We will be all the more happy to help. Thank you so much.